Hi, this is Kevin Sutton of Lusk Albertson, and I want to talk to you today about a recent decision that was issued by the Michigan Court of Appeals, a decision which tells us that things sometimes can turn out okay for the school district, but there may have been a better way to handle the situation when it arose. The case arises out of the Grand Rapids School District and involves a situation at an elementary school. There had been a teacher who needed to go on leave, and a private substitute teacher was assigned to the elementary building through the third-party contractor PESG. The teacher, while out on leave, had received some reports from her colleagues about some curious behavior between the substitute teacher and one of the students in the class, a 13-year-old developmentally disabled female student. The activities that were of concern to the teacher who was on leave included the substitute teacher taking the student's hand to escort her to the bus, trying to move the student from classroom to classroom, the substitute giving the student back rubs and tickling her, the substitute taking an inordinate amount of pictures of the student as compared to other students, and ultimately the substitute teacher switching churches to attend the same church congregation as the student and her family. The teacher who was out on leave had witnessed none of this behavior, but again it had been reported to her by some of her colleagues. The teacher raised these issues with the building principal, and the building principal in turn asked the teacher to document her concerns in a written letter. In that letter, the teacher who was on leave identified all of the items that had been expressed to her, and then closed the letter by stating, while I'm not in any way making any accusations on what may or may not have happened or will happen, there are too many red flags for me not to have acted on this information. Once in receipt of the letter, the school district terminated the services of the private substitute teacher, and PESG subsequently informed the teacher that they would not be placing him at any more buildings. The teacher was understandably upset, filed suit against the school district, as well as the teacher he had been subbing for, claiming defamation, intentional infliction of emotional distress, and some other tort-related claims. The district responded by asserting that they were protected by governmental immunity and that the Michigan Child Protection Law compelled them to look into allegations that the substitute teacher, may be engaged in activities with a student that were inappropriate. The Court of Appeals agreed with the trial court that the district and the teacher who had been out on leave were well within their rights as mandatory reporters under the CPL to write the letter, and that any activities that had happened with PESG and the former substitute teacher was between that individual and PESG. So ultimately, governmental immunity was upheld. The district and the teacher that had gone on leave were found to have no liability. So things turned out okay for the district and the teacher. But the situation presents an interesting question of what could have been done better to potentially avoid litigation. And if a situation like this were ever to arise in your district, my recommendation would be that the principal should have taken a different course of action. Instead of asking the teacher who had been on leave merely to document the concerns that had been relayed to her in a letter and then using that letter upon which to act against the substitute, I would recommend that the principal launch an investigation upon receipt of those complaints. In my mind, the principal would have been better served to call in the individuals who had shared the information with the teacher on leave, interview those individuals, and document those concerns, and use his investigation report as a basis to have the substitute teacher removed from the school. And then whatever had happened with PESG would have been the problem of the substitute teacher. Again, an interesting way to take a look back at a situation that turned out okay for the district, but in hindsight may have been handled a little bit differently and perhaps slightly more effectively. That's all for now. As always, check back to luskalbertson.com regularly for updates on the latest cases and developments in the world of education law. Thank you.